can sue these for you. I know what I'm doing. Nope, I might not be a trained barrister, trained solicitor, but I am extremely knowledgeable within the legal sector.
Today's story begins at a job centre in Folkestone, where an auditor called Alfie Audits seems to want to serve some sort of notice on them.
It's Monday, I don't know the date. We're going to check out what there is to see. I know there's some public notices, so we do the best we can. Let's go. Hello. You gotta read my notice, or not even notice.
We're gonna have to just
come on.
Wait outside for a minute.
No, I'm not waiting outside. You can
wait outside for me.
I'm not gonna go for that. You can relax. You can relax, sir.
No, it's fine.
Can you just read this and then we're gone? I won't have to come back.
Outside, I'll get manager to come read it.
No, he didn't read it last time.
Well, I'll get to read it this time. You have to wait over there.
He didn't read it last time. I'm being fair to you. I'm not going over there because I'm not allowed over there.
No, but just wait for you. If you wait outside, I'll get manager to come and read it.
No, I'm not going outside.
You need to wait outside for
I can wait over here. You've got loads of public notices here, I see. I'm not going to go over there, you can relax. What's the guy about anyway? Why do you not want me in?
I'm not in this one because it's appointments only. You haven't got an appointment.
Yeah, I'm not over there. This is the one.
The actual building's appointments only.
Yeah, I know.
Inside.
Yeah.
You've got an appointment.
No, I understand that. That's why the public ain't allowed over there. But this like public access.
No, this is public.
If you read
this,
if you read this will explain.
I shouldn't have to read it because there's nothing to do with me.
No, it's to do with the DWP.
No, mate.
I'm not talking to you.
No.
You're rude to me.
No,
you are.
I'm the team leader.
I'm trying to talk to him because he's more pleasant today.
Go back.
Hello there. How are we doing? Can I please ask you to stop filming?
You done this last time.
I did.
I'm not going to have an archive. Can you read this, please?
No.
Right.
So the guidance you have is for people with appointments,
yes,
not for people just dropping in off the street. So
if you read this,
please
it'll
stop filming.
No. It will include about recording inside and outside the building.
Can you please leave the building?
I will in a minute. But can you read this?
No.
Harassment. Can you read the Harassment Act?
Please ask the gentleman to leave the building.
Can you read this? Concerns your staff.
In that case, I'm going to go and call the police.
So are you refusing to leave?
At the moment,
you are
yeah.
trespassing then. You're trespassing.
You said this last time. This actually says, if I get any staff, claimants or anyone like that, and then there's a protection from Harassment Act 1997.
You've been asked to leave the building.
Can you? Are you read? Yes, I
can't make head or tail of what he's doing or why he's there. Whether or not he was trespassing to begin with, I'm not going to go into that. They've now asked him to leave, and although a job centre is a public amenity, it is still private property, so he must leave if asked.
If you'd like to hang around for them, that's entirely up to you.
I will.
We would like you to do it outside.
I'm not going outside.
I'm not
going outside. I'm going. Don't touch me.
Don't walk
Please
into me. Don't walk into me.
I'm not walking into you, mate.
You're not coming.
I'm not walking into you. I'm not going over there either.
You're going outside.
Can you see all this?
It is established law that the occupier, in this case the DWP, for whom the F.S.R security guards act as agent, the occupier is allowed to use such reasonable force as is necessary to remove a trespasser.
Come on. You're obstructing my
You can't go past the public area,
You're obstructing my freedom of
You cannot go past the public area. Move outside.
Please. No.
You haven't got an appointment. You can't go past the public area, mate.
Look at nah. What are you doing? Why are you doing this, mate? What are you doing? Criminal damage, yeah? Criminal damage.
Trespass.
Listen to you. Look at you. I don't care.
Bye.
Yeah, I'm not. What are you doing?
They've used the necessary level of force to remove him from the premises. I see nothing unlawful in what they've done, given that he was refusing to leave. Indeed, he was trying to walk further into the job centre rather than leave.
What are you doing? What are you doing? Get the police.
Are you forcing your way in?
Yeah,
Are
get
you
the
forcing
police.
your way in?
Get the police.
Okay, nice. You're
Yes,
forcing your way in.
get the police.
Lay hands on me.
Public.
Lay hands on me.
Yeah, and what? I'm not going to do
What are you
nothing.
threatening then? Is that what you're doing?
Self-defense.
Here's the same incident, but from the viewpoint of a body cam worn by one of the security guards.
No.
Harassment.
So,
Can you read
in
the
regards
Harassment
to
Act?
Please
Yeah.
ask the gentleman to leave the building.
Can you read this? Concerns your
In
staff.
that case, I'm going to go and call the police.
So are you refusing to leave?
At the moment,
You are
yeah.
trespassing then. You're
You said this
trespassing.
last time. This actually says, if I get any staff, claimants or anyone like that, and then there's a protection from Harassment Act 1997.
You've been asked to leave the building.
Can you, are you
Been asked to
read
leave the building
Yes,
quickly,
I understand
and
what
police
the
have now
question
been
is.
called, so if you'd like to hang around for them, that's entirely up to you.
I will.
We would like you to do it outside.
You can't
I'm
go
not
that
going
far,
outside.
sir. You cannot go
I'm not
You're
going
down
outside.
there.
I'm going. Don't touch me.
Don't walk
Please
into me.
don't touch-
Don't walk into
I'm
me.
not walking into
You are
you,
walking-
mate.
you're not coming
I'm
this
not
way.
walking into you. I'm not going over there either.
You're going outside.
Can you see all this?
Come on, you've been asked
Come
to
on.
leave. The police have
You're obstructing my
You can't go past the public
You're
area, sir.
obstructing
Move
my
out.
freedom of
You
freedom
cannot
of
go
going,
past the
mate.
public Move area.
Please,
It's not-
no.
You haven't got an appointment. You can't go past the public
No.
area, mate.
Look at nah. What are you doing? Why are you doing this, mate? What are you doing? Criminal damage, yeah?
He then explains it all to the police.
Done something different to. Okay. So basically, I've got the recording on here, but I can't show. At first, I can't show what happened because the screen is busted. Look. Okay. But there is a possibility I can get the SD card out. So you've heard of audits?
Yes.
Right. So I've gone into the job centre with paperwork, which I'm going to show you now.
Okay.
But the manager is so politely saying the word to describe is arrogant and ignorant. He didn't want to know. Okay. Second time, I was polite, civil, I'm in my rights. So basically, this is to say to whoever reads it that the person who's holding the paperwork or anyone is allowed to go in the job centre and record what goes on in there. But my intention, as you know, audits, we go in, get public information. That's stating the GDPR Act does come into effect and harassment when I record data breaches, people's faces, claimants, etc. And it also states that I'm not the person doing the recording. It's not allowed in the claimants part to record because obviously GDPR. So I've never gone over there. Whether they know that I know I'm not allowed to, I've not gone over there because I didn't want to get in trouble.
But you were trying to walk over there. We've just seen it in the footage. So as usual, like all auditors, you just tell lies.
I wanted to do this civilised and the best way I could because it's local to me, but I wanted to go to the job centre. I've been to the other job centre, of course, next to the police station. That's fine. They didn't like it at first, but I went back with paperwork, they read it, that's fine. Absolutely. They even welcomed me in there as long as I didn't get people's claimants' faces on camera. So what happened? I went into the job centre. Second time now. This is today. The first time was about 2-3 weeks ago. Same people as last time, and I'm the same person. So they obviously knew what I was there for. They didn't like it because I got a camera and they just don't like it for whatever reason. Put their policy, which I understand, but I was trying to tell them the circumstances in the policy, and I was trying to give them the good side before it switched, and they switched it without even me saying I'm going to go do that. I was just taking pictures of that, and I had, I don't know, two G4S in front of me to stop obstructing me doing what I was doing, the public notices. I wasn't going over the other side of the claimant part. I wasn't going nowhere near the threshold. There's a big carpet in there, which I believe was public access, until you go past the point, which is applications and claimants. And so they didn't like that. Trying to get my thoughts together because it all went so quick. I got panicky after, and they reacted in the best way to say it's unprofessional. They could have handled it completely different. They could have read that, and I'd have been out 5 minutes, not even that. I've done it elsewhere. And as they pushed me out, I was trying to. They had their foot there, and they pushed me out like that. But I was basically saying, look, you're not pushing me out because I ain't done nothing wrong. Until the police gets here, they're the only people who can say, you know, advise people, the party is a trespass, can you leave? And I was going to leave.
There he repeats another typical YouTube auditor myth that only the police can remove trespassers. That's not correct. Actually, the exact opposite is the case. Absent of aggravated trespass, a police officer who removes a trespasser is risking prosecution for assault because being authorised by an occupier to remove a civil trespasser is not part of his policing duties. The police are not needed or required in these circumstances anyway, typically. Yes, sometimes police are called to these situations, but that would only be to ensure there is no breach of the peace while the trespasser is dealt with, which may include physically ejecting him. The G4S security guards are authorised by the job centre to do just that and can decide if somebody is trespassing and remove them. If the trespasser refuses to leave, there will be little point to their presence in a job centre if they did not have that role. Who else do you expect to do it? The manager? A work coach? The cleaner? One of the claimants? Auditors just talk so much crap, it's hard to keep up.
But, you know, I'd rather have the police there too.
At any point, did they say that they were that you had to leave? Did they ask you if you'd leave?
Yeah, a few times they did. Okay. Yeah.
That's case closed then, or it should be.
So the only thing I'll say to you is that at the moment that they say to you, we would like you to leave, that they technically, the point that you've been asked to leave is the same as, say, for instance, if you was going to a bar or a restaurant or something like that, and you get asked to leave. At the moment that they ask you to leave, and I'm not saying you were refusing to leave, but that is the point that you've been asked to leave, and therefore technically you're then classed as a trespasser.
Yeah.
That is exactly correct. The only thing I would add is that it could be argued that he was trespassing from the start, as he had no proper reason for being there. I am open to an argument that a claimant or job seeker could film inside a job centre. It is a public amenity, and I can think of some potentially legitimate reasons why filming could take place, but this person had no reason to film. He's simply wasting everybody's time.
Yeah, I understand that bit, yeah.
You understand that bit? Yeah. What are we doing here then? That's what the nice policeman should now be asking him. I assume there are people in Folkestone who actually need the police. While some old granny shivers in terror upstairs as a burglar rifles through her living room, these two coppers are preoccupied with this time-wasting idiot.
So what I need to establish...
What we need to establish? Why do police officers nowadays talk in that silly diplomatic language as if they're delegates from the United Nations? Anyway, before we go on, I can't resist it. He's just put across the screen there, trespass is a civil matter. What I always say in response to that is that trespass is a civil matter amongst normal people. Auditors are not normal people. Their intentions are not normal. Almost invariably, when an auditor steps foot on private property, by the end of his visit, he will have at least created a minimum argument that an aggravated trespass has transpired.
And that will be from your footage and from the footage that they've got there.
Yeah.
The circumstances of the events that occurred around it.
Yeah.
Okay. And I think probably what's happened is that you've gone in there with the best intentions. And I think what's then happened is that it's spiralled and it's escalated, isn't it?
But this is my point. What I said last time, I was a bit angry because the way they treated me, but not as bad as this one.
Yeah.
I thought G4S was supposed to be trained to, I can't say the word, escalate, to instead of getting the
de-escalate.
That's the word. So
one of the reasons I don't like that word de-escalation is that sometimes it is necessary to escalate an incident, and people have adopted this word de-escalate and the word de-escalation as a sort of fluffy fill-in for not really looking at the facts and thinking about what really happened during an incident. In this case, the auditor was trying to walk further into the job centre while filming. It wasn't enough for him just to hand over this notice he had. He couldn't be reasoned with. What were the security guards supposed to do? Ask you in a nicer tone? Offer you chocky bickies? I don't see what the point of all this is. Yes, de-escalation is preferable, but in this case, what other options did the security guards have?
So it's in their training to do that.
Yeah, absolutely.
They could have behaved completely different, or they could have worked with me. And they could have worked with me.
Absolutely.
But they didn't. They didn't want to know.
This is rubbish. They carried out their training in response to an incident that you provoked. There was no working with you, as you're not a normal, reasonable person.
Instead, sorry to jump in. Instead, they refused. They done what they'd done, and then they put the cam. I had the camera in my hand, and they. I don't know what they'd done, but they pushed me on my arm, and they also break that.
Right.
And that shouldn't be acceptable. They should have. I don't know how they could have handled that, but the camera was in my hand, so there's no need to grab my hands or my arm, whatever they've done.
So what I'll do then, if it's okay with you, so I can take some details from you.
Yeah.
Are you able, with your camera, with your SD card, are you able to email that footage across to me when you get home? Is that something that you can do?
Yeah, I've done that before.
Okay,
yeah.
brilliant. So what I'll do then is I'll grab some details from you. I'll give you my email address. If you're going to email that across to me, then I can review that. They've obviously got CCTV in there, they've got body cameras from in there, and I'll get all of that footage. But what I want to do is I want to look at the footage from all parties.
Yes, of course.
And then obviously we can all make an informed decision
Yes,
about
of course.
What's actually happened, and then we can get the matter dealt with, can't we?
Yes, of course.
At the last count, Folkestone had a population of just over 46,000 people. I assume there are people in that town who actually need the police. I wonder what they think when they watch stuff like this. Anyway, now someone else enters the picture.
Hi guys, welcome back to the channel, if it's your first time around here.
Hi guys, welcome back to the channel, welcome to the channel if it's your first time around here. Yes, it's him.
So, well, proof is in the pudding, so let me show you the pudding.
Show you the pudding? You're a pudding.
Yes, I have successfully sued G4S Security, that is G4S Security Solutions Limited, or something like that anyway. We'll see it on the letters in a few minutes. So how did this come about? Well, I sued G4S on behalf of Alfie Audits.
That's the auditor you've just seen causing trouble at Folkestone Job Centre.
So Alfie did an audit a bit back. It was in April this year, a job centre in Folkestone. Now, whilst he was there, he was assaulted, which also led to the damage of one of his cameras.
He was not assaulted. That is simply a lie. You've just seen yourselves. I've just shown you that Alfie Audits was trying to walk further into the job centre and ignoring instructions to leave, and the absolute minimum level of force was used against him, sufficient to eject him from the premises. That means he was lawfully ejected from the premises. If anything, Alfie Audits was the one who committed an assault against the security guards. If his camera really was damaged in the process, then that's his own fault, frankly.
And as we know full well, when the police do stuff like this, you know, we have people at HNK to turn to who will sue the police and take civil action against them on our behalf. However, unfortunately, unfortunately, HNK nor any of the civil litigation firms will touch the private security industry. They just won't do it. Why they won't do it, I don't know, but they won't.
Yes, they will. Solicitors bring civil claims against private security firms on behalf of their clients all the time. Here's a 2014 blog post by Iain Gould, a solicitor often instructed by auditors, telling us how to sue private security companies. In this, Mr. Gould talks about an assault and false imprisonment claim he made on behalf of one of his clients against a private security company. And here's an article from Hudgell Solicitors in which they tell us how they won £35,000 damages for a man who was punched and kicked by a private security guard. In another case, Murray solicitors acted against G4S in a false imprisonment claim against a Birmingham NHS trust. Very interesting case, that one. The reason HNK solicitors won't help Alfie Audits with his claim is either because they've seen the video and realise there's no claim, or they just think that any damage he may have suffered is not of a monetary value that would justify their time. They are, after all, a business, and it is typically the case that if the value of the claim is likely to be less than, say, £1,000, it is hard to persuade a solicitor to act. Having said all that, don't forget that Marti is a legal expert, so it could be that these claims I've been referring to actually never happened, and these solicitors and the courts have just made it all up, and there's some sort of conspiracy afoot to deceive and trick us. It could be that Iain Gould was sitting in his office bored one day and just made it all up in a daydream. Carry on, Marti.
So I thought, right, this is not right. I think I can do something about this. So I spoke to Alfie and I said, you know what, mate, I can sue these for you. I know what I'm doing. Nope, I might not be a trained barrister, trained solicitor, but I am extremely knowledgeable within the legal sector.
You're not. Your own YouTube channel isn't even compliant with basic data protection law. You struggle to even understand the basics of trespass law, which has to be one of the easiest areas of the law for a non-lawyer to get to grips with. You don't learn the law from experience or by making it up as you go along, or just making it up in this case.
I know how to produce legal documents, I know how to handle these kind of situations, so I did it. And yeah, short story short, we won. So before we continue, let me just show you a quick little clip of what actually happened and the key moment that resulted in the damage to Alfie's stuff.
I thought you said he was assaulted as well. Anyway, we'll watch it again.
Going over there either.
You're going outside.
Can you see all this? Come on. Well, I've got some my
You can't go past the public area, sir.
Move
out.
freedom
You cannot go past the public
mate.
area. Move outside.
Please, no.
You haven't got an appointment, you can't go past the public
No.
area, mate.
Look at that. Nah. What are you doing? Why are you doing this, mate? What are you doing? Criminal damage, yeah? Criminal damage.
Trespass.
Listen to you. Look at you. I don't care.
Bye.
Yeah, look. What are you doing? What are you doing? What are you doing? Get the police.
Are you forcing your way in?
Yeah, get the police.
Your way in?
Get the police.
Okay, nice. You're forcing your way in.
Get to the police.
Hey, hands.
Right, so you've seen what happened there, and there might be a lot of conflicting beliefs. So he's been asked to leave and he didn't leave. So was it trespassing? Potentially, yes. But did they use unreasonable force against him? Well, yes. You see, the law is not super clear, and it could do with clarification.
If the law weren't clear and could do with clarification, then how would you be so sure that they did not use reasonable force? I disagree anyway. It doesn't need any further clarification. It has been the law for hundreds of years now that an occupier can use such reasonable force as is necessary to eject a trespasser. When Marti says it's not clear, what he really means is that every situation is going to be different, and so when these cases come to court, which is not very often, the court has to look at the particular facts, which is why it's hard for the judiciary to set down firm guidelines on what occupiers should and should not do.
But just because someone is refusing to leave, you shouldn't always just turn to using force.
And nobody is suggesting that you should, and they didn't. The clip you've just shown us, Marti, is only part of the incident, and it's the incident only from one angle. What you missed was the part I showed earlier, in which the auditor is refusing to obey their request that he should leave. He deliberately walks into one of the security guards, then lies and claims he was assaulted, and he tries to walk further into the job centre while filming. You haven't mentioned any of that, Marti. I wonder why.
And if you do use that force, it should be reasonable. Reasonable force is very simple. It's reasonable, common sense, it's not stupid.
And what we just saw was reasonable force, and you know full well it was. They didn't beat him up. They didn't use baseball bats on him. They didn't kneecap him. They didn't bundle him into a van and take him to Auditing Yorkshire, the big man in Huddersfield, for a proper beating. That was just a joke, that last one. They just ejected him from the premises, and you know that, Marty. It is actually quite clear.
But one of the actions that were taken in this video, what the security did is they pushed Alfie into his chest and pushed him backwards. Now that is a big no-no. That is not classed as reasonable force, because if you push somebody like that, you have no control of where and how they are going to fall and land and injure themselves. When you are moving a person using reasonable force, you're supposed to use CNR techniques, which is control and restraint. So you would take hold of their body, their arms, lead them to the place where you want them to be, and then release them. You don't push and you don't shove. So that was unreasonable force.
Oh, Marty, somebody push me, get me some compo. I disagree, because I think the security guards did use acceptable techniques, even if they weren't strictly approved techniques. To put this into context, this was not somebody who was a physical threat to anybody in the job centre, and nobody is suggesting he was. This was somebody who was simply refusing to leave and continued to walk further into the job centre while filming and ignoring instructions to leave. There was no need for the security guards to restrain him, and had they done so, they would have been rightly accused of assaulting him. There was, however, a need to control him. In those circumstances, the security guards did two things. First, they blocked him. That's a passive method of control. Then they worked together to physically usher him towards the door without actually touching him. Again, that's a passive method of physically ejecting him. Then as he neared the threshold, he resisted, so they used their hands to force him out the door, and continued to do so as he tried to get back in. At no point did they push him. There might have been something in Marty's argument if they'd pushed him back to the door and nothing else, especially if this had happened over a significant distance. Because there is something in what Marty says, in that when you push somebody, that person could fall back and suffer injury, and I'm certainly not being dismissive of that point in principle. It's just that that's not what happened here. Marty is just trying to apply a preconceived idea of his own to the situation, which is borrowed from somewhere else, to make it fit, because he doesn't like the fact that G4S and their security guards are in the right, and rather than assessing the situation as it actually was, he's biased against them. There was no risk to this man at all, other than the risks he was causing himself. The methods that I think Marti Blagborough is thinking of, and that admittedly you do often see police and security guards use in these types of situations, are what's called the escort hold and wrap methods. And here's a demonstration of the escort hold.
Hello everybody, my name's Piers Carter and this is my colleague Martin Smith. We're going to do another one of our AVH interventions tutorials. Today we're going to move on to our level 3 training package, which is based on control and restraints. We have two levels. One is a soft restraint module and the other is our basic control and restraint module. So first of all we're going to look at the escort hold, and then we're going to look into a full arm wrap. If I take the escort hold initially, I've got the person that I'm trying to control here. We're talking about very low levels of physical resistance, and I'm just holding and controlling the arm. You'll see that my outside arm is going to grab hold of his wrist at the narrowest part with the thumb and forefinger around the wrist, the rest of my hand over the back of his hand, and then my other arm is going just above the elbow joint there, and I'm able to move this assailant or this person that I'm trying to restrain around, and if I need to disengage I can actually push them away and let go. So the basic escort hold is a great place to start, and a lot of our other techniques will stem from the escort hold. If we do need to escalate, then you're looking at a higher level of control, and rather than creating distance, I'm actually going to close in and get closer to this aggressive individual. The hand that was on the elbow moves in and pulls his elbow in next to me. The closer it is to me, the harder it is for him to actually hit me, because I've closed all that distance down, and I'm able to control this wrist and his arm. Now in an ideal world I'd have a colleague on his other arm as well, so that was being controlled. And then from here it's very easy to escalate again, and if I needed to move the aggressive person backwards, I could switch very quickly, and I'm able to push his arm underneath mine, and I've actually got control of his elbow, control of his upper arm, and then we can move him where we need to move him to. So the whole progression of techniques went from the basic escort hold to the full arm wrap to a switched arm wrap where I'm facing the rear. And that allows me to escalate the level of control that I've got over this potentially aggressive person. Thank you very much.
And here's a demonstration of the front and rear arm wrap.
Hello and welcome to our next AVH Interventions tutorial. Previously we had a look at what we call an escort hold from our level 3 package, which is our soft skill restraints. We're looking here at being able to control a client or a patient or a resident in a less than confrontational situation. We're trying to get that control without the use of restraint that has any joint locking or pain compliance. I'm Martin Smith and I'd like to introduce you to my colleagues Piers Carter and Lee Smith. We're going to demonstrate now the use of the escort hold in our full arm wrap position, but using now 2 members of staff rather than the one we previously demonstrated. So both of us have got now a control on the arm. Here's the escort position that we spoke about previously, making sure that the hand is just around the wrist area here and just above the elbow joint, so you've got some control, and between us we can move our person around fairly easily but also fairly safely. So we've got some control over the person. They're not too non-compliant at this moment in time. Within our package we talk about a yes, no or maybe person. This is either a yes person or a maybe person rather than a completely non-compliant. From this position, should the struggle start to get more difficult and we need to get more control, then we go into what we call the full arm wrap. So I slide through and take my arm right the way through here, and Lee's going to go into the same position. One of those crucial parts of this is to have communication between the members of staff. Quite often in these stressful situations we get locked into our own way of thinking and our own doing. So we're moving, the other person's moving, but nobody's communicating. We've found through experience that even if this individual can hear us talking to each other, it's not a detriment, it's actually a positive, because they then realise that we've actually got control and we know what we're doing. So here we've got the full arm wrap. We can move the person forward, sideways, backwards, wherever we want to go. If it gets even more difficult, because this is a vulnerable position still for both members of staff, obviously legs and kicking and these sort of things can occur as it's happening, and it's more difficult to control the arms sometimes, but we keep it nice and tight. What we can do is switch to a position at the back for the full arm wrap. This is done, both members of staff are going to change, but one at a time. So we communicate with each other. So I'm going to change first and I communicate that to another member of staff. I'm going to move, you stay in your position. Okay, so I'm switching and I get to here. At this point, when I feel secure, I will shout secure, next person move. Therein, we're pushing forward, we're pushing forwards this way as opposed to so that they can control the person. Care has got to be taken that we don't fall over, and especially when you're moving somebody backwards, you've always got to be mindful of what they're struggling to keep up with us. But that's an advantage again with the control. So here we are in the full arm wrap position to the back, where we can now move, and also we can take down to the floor, which we can do in follow-up tutorials, and also then we can switch back to a seated position. So that's the escort, the front full arm wrap, and the back full arm wrap using 2 members of staff. Thank you.
I do think those techniques would have been a bit over the top in this case, as Alfie Audits was not being violent as such, or threatening violence, and the entrance was quite nearby. I think the control techniques used by the security guards were fine and were the appropriate level of force for the particular circumstances. The other point I would make is that these restraint and control techniques that Marti Blagborough refers to are all very well in theory, but they often don't work well in practice. In the real world, security guards must deal with the situation they face as best they can. Textbook and classroom techniques are important to learn because they form the approved techniques of the private security industry, but they can't be applied rigidly because every situation is different, and an approved technique will not always be the appropriate technique for the situation. This brings me to the fundamental reason why Marti Blagborough is wrong. In arguing for restraint and control techniques, what he's arguing for is direct physical intervention in which the security guards physically restrain Alfie Audits at some level. Had that happened, there's no doubt in my mind that Marti Blagborough would still be saying that Alfie Audits had been assaulted. As it is, the security guards in the job centre use passive control techniques and minimum physicality to physically eject him. I see nothing wrong with what they did. The minimum use of physical intervention is a very important guiding principle in the private security industry. I'll now show you a clip in which a lecturer explains why.
Remember, the longer the restraint is used for, the greater the exposure to risk and complication. We all remember what happened to George Floyd in the United States of America. Yes? When the police officers, when they restrained him for a very long period, he complained, "I cannot breathe." They ignored the warning. And what happened? He died. So we don't want a repeat of such situation. So for whatever reason, no matter how challenging the situation is, if you're restraining someone and there is any signs of difficulty as mentioned, you should stop restraint and attend to their concern. It is not your duty to want to establish whether they are lying, whether they are pretending. You need to make sure that they are safe. You monitor them, their safety, and ensure that your own safety is also in order. Do not jeopardize your safety at any point in time. Make sure the person you're restraining, you don't handle them in such a way that can lead to injury or death.
He makes excellent points there. Restraint and control techniques are high risk. It's important to understand that restraint and control techniques are only part of the picture. I've linked to that lecture and others in the video description because he does go into the subject in some depth. I'll just add this short clip as it's quite relevant to the point I want to make.
Physical intervention skills include guides, deflection, blocks, escorting holds, disengagement techniques, and restraint. For you to be able to restrain someone on the ground, or standing, or sitting down, you must be able to justify it.
Even if restraining Alfie Audits could have been justified, the general point the lecturer is making here needs to be heeded, in that to restrain Alfie Audits brings into it a need for another level of justification, as well as all the attendant physical and legal risk. The techniques used by the security guards at the Folkestone Job Centre were enough. While we're here, let's see what the same lecturer says about the use of physical intervention techniques in trespass situations specifically. And he addresses here again the point about justification.
A trespass is committed by a person who is improperly on someone else's property without consent. The law says that no more force is used to remove trespassers from your premises. No more force is used than is necessary to remove trespassers from your premises. The use of force must be reasonable, must be necessary, preemptive strike, and justification. That is, whenever you use force, you must be able to justify it. Yes, the force you use must be reasonable and necessary. Yes, and before you use the force, it must be a preemptive strike.
I think, with due respect, he's confusing the use of force against trespass with the use of force in self-defence. An occupier and his agents can use force against someone because they are trespassing, provided it is such reasonable force as is necessary to remove the individual from the premises. It doesn't have to be preemptive. For instance, it's not necessary that the occupier should show that the trespasser would have walked further into the property. It is only necessary that the occupier should show that the individual was trespassing, and the level of force used was reasonable and only to the extent necessary to remove him. However, the need to prevent the trespassing individual from doing something could be relevant to whether the force used was reasonable, so to that extent the point being made by the lecturer about a preemptive strike is of some relevance. At Folkestone Job Centre, Alfie Audits was trying to walk further into the job centre, and that was partly what motivated the actions of the G4S security guards and helped make it reasonable and helped to provide the justification for the use of force. Let's go back to Marti Blagborough.
So, what did I do? Well, first things first is I drafted up a letter of claim, essentially.
Importantly, let me just stress that although Marti Blagborough is not a lawyer, there is nothing legally to stop Marti Blagborough representing Alfie Audits in a letter before claim, and he can also be paid by Alfie Audits for carrying out this work. At least taken in isolation, this is perfectly legal. Marti Blagborough is doing nothing wrong here.
And I sent that to the job centre and to G4S, because at that moment in time I wasn't entirely sure who I was meant to be making the claim against. Was I making the claim against G4S because they're the ones that did it, or was I making the claim against the Job Centre Plus because they are the ones that employ G4S? Turned out it was G4S. They were liable for their own actions.
Technically you don't sue job centres as such anyway, because Job Centre Plus forms part of the Department of Work and Pensions. A job centre is not a separate legal entity, so what you would actually do is serve the letter before claim on the Department of Work and Pensions. But that's just a quibble. I'm not going to argue with that last part about just pursuing a claim against G4S and not the DWP as well, but it does raise an interesting question of law. There's a concept in the law called vicarious liability. G4S is an independent contractor and its security guards are employees of G4S rather than the DWP. And it is true that when an independent contractor is engaged by an employing entity such as the DWP, there has generally been a defence that the employer was not liable for their actions, broadly on the basis that the contractor was not under the control or direction of the employer. However, I think it is open to argument that this general defence does not apply here, because G4S and its security personnel are acting under the control of both the DWP as a department and are under the control of the management of a specific job centre. A case of relevance to this is Barclays Bank and various claimants. In the Barclays Bank case, the Court of Appeal took the view that the independent contractor defence that I've just described no longer exists. Employers may potentially be liable for the actions of third-party contractors. The case concerned a doctor who carried out medical examinations for Barclays Bank as part of their recruitment process, and he was an independent contractor. He allegedly committed sexual assaults, and the victims brought civil claims against the bank. The bank tried to argue that they were not liable because the doctor was not an employee or worker of the bank. He was an independent contractor. The Court of Appeal rejected the bank's defence and held that the bank was still vicariously liable for the actions of someone even though they weren't an employee. The question involved a two-stage test. First, is the relevant relationship one of employment or akin to employment? And if so, was the wrongful act connected to the duties of the contractor that he was hired to carry out? The Court of Appeal decided that whilst the medical examination being carried out by the doctor was of some benefit to the prospective employees, it was clear beyond doubt that the principal benefit of the medical examinations was to the bank, and the process was part of the bank's business activity. Most crucially of all, the doctor was to a greater or lesser degree under the control of the bank. Barclays Bank then appealed to the UK Supreme Court, which decided that the Court of Appeal had been wrong and Barclays Bank could not be held liable for the alleged actions of the doctor. This was on the basis of certain facts about how the doctor carried out his work, as follows. The examinations were undertaken at Dr. Bates' home. The bank arranged the assessments, advised the applicants to attend and provided Dr. Bates with a pro forma report to complete, but Dr. Bates was not obliged to accept any particular applicant. Dr. Bates was paid a fee for each report, rather than being paid a retainer by the bank. He did undertake other work. Put another way, the classic distinction is between work done for an employer as part of a business of that employer and work done by an independent contractor as part of a business of that contractor. What the Supreme Court seemed to have done is upheld the general defence for employers in cases where the contractor is clearly operating independently. But is G4S clearly operating independently of the DWP? Can we really say that? I'm not convinced. Certainly G4S is legally an independent contractor, but that is beyond dispute. But the nature of the work that security guards carry out at a job centre does suggest to me that there may be scope for an argument that the DWP are vicariously liable for the actions of G4S security guards. That having been said, even if Marti Blagborough had served a letter before claim on the DWP as well, it would not have troubled the DWP greatly, as their contract with G4S should contain a clause called an indemnity covenant, which requires that G4S are responsible for any damages that may have to be paid as a result of the actions of their own staff deployed in the DWP estate.
So, off we go with the letter. So let me show you this first letter that was sent. Right, so I put the letter here on full screen so you can see it all. There is a few bits of redacted information, just, you know, Alfie's personal information and a few other things that we can't put out there.
When has that ever stopped you?
For whatever reason, just take my word for it. So, DG4S Limited and Job Centre Plus Limited. This notice is sent on behalf of Mr. Alfie Audits. I am writing to inform you that I intend to initiate civil proceedings against your company on behalf of the above forenamed for criminal damage caused to his property and battery with injury caused to his person. On the 3rd of April 23, your company's workers caused damage to Mr. Alfie Audits' property, namely a handheld video recorder, and injury to Mr. Alfie Audits' body in the form of ABH, actual bodily harm.
Let me stop it there and say that Marty does accidentally reveal Alfie Audits' real name at this point. It's in the letter, and he shows the letter on the screen in his original video, so viewers of his video know Alfie Audits' real name. I've blurred it out as I have no interest in such information. Also, Marty is alleging not only that a battery took place, but also actual bodily harm, or ABH. The offence is assault occasioning actual bodily harm, contrary to section 47 of the Offences Against a Person Act 1861. That suggests to me that Alfie Audits must have been injured, even if it was only a minor injury, but as far as I'm aware, there were no arrests of any of the security guards. The relevant civil wrong would be trespass to the person, which is the civil equivalent of an assault or battery.
In the course of a situation that begun at 1623 on the above date at Folkestone Job Centre Plus, 14 Sandgate Road, Folkestone, CT21DP. As a result of this damage, Mr. Audits has suffered losses amounting to £55 for his camera equipment and personal injury damages to the value of amounts. It is not yet clear if Mr. Audits has suffered or is still suffering any psychological damages. I am therefore left with no other option but to pursue legal action against your company to recover the losses Mr. Audits has suffered as a result of the criminal damage and personal injury. I would like to remind you that under the law, your company is strictly liable for the actions of its employees and equipment. I therefore request that you take immediate steps to address this matter and offer compensation for the losses Mr. Audits has suffered. Please take this letter as a formal notice of my intention to pursue legal action against your company. I am willing to settle this matter amicably on behalf of Mr. Audits, but I reserve the right to initiate legal proceedings if necessary. I request that all contacts in relation to this matter be sent to myself. Mr. Audits does not wish to be directly contacted by G4S Limited or Job Centre Plus Limited in relation to these legal matters. I request all contacts be made in writing. I have attached separately photographic evidence of damages caused, along with ability to view video footage of the situation. A subject access request has already been issued to your agency for the copies of the CCTV and body-worn footage. I look forward to hearing from you soon. So very quickly after that, just 9 days later, we received a response from G4S, which I'll put on screen now. And as you can see, it states that they have received my letter, and they've requested a letter from Alfie to clarify and provide information to confirm that they are authorised to respond and communicate with myself on his behalf. Pretty simple.
I'll jump ahead because the next part is just him explaining how he got Alfie Audits authority, which is routine.
And just on the 28th of July, which I don't think it was that long considering, you know, they can take longer, but they've asked, put the letter here. Please note our new address, so they've actually changed addresses. So at the top it's now 50 Broadway, London. And it just says that, so regards to the claim, we would be most obliged for further details of the basis of the claim for £55 in respect of the camera equipment, i.e. is this a replacement value or repair cost? We would also be most obliged for confirming as to whether Mr. Audits has sought medical assistance in relation to his injuries. So I spoke to Alfie and I got some information from him regarding both of them subjects, and I responded with the following letter on the 18th of August. Dear G4S Legal Department, thank you for your letter dated 28 July. In respect of the claim for £55, after speaking with Mr. Audits, I am informed that the £55 was the original cost price before postage. The full price of the original purchase was in fact £74.44. I attached proof of purchase via eBay. As currently the closest available replacement of this item is £68, also from eBay, I attach proof. I can confirm that I did ask for £55 I would accept today. Regarding medical assistance, I asked Mr. Audits about this, and he has informed me that he did not seek medical services as it was only bruising, and he says, quote, it was only bruising, I didn't think I needed to go to hospital for that. The police also said they didn't think I needed hospital. And I said, due to Mr. Audits' special needs, I would take the viewpoint that medical assistance was not required for the level of injury sustained. I hope this answers your questions to assist you further in dealing with this matter, blah, blah, blah. I attached this, which was just a printout of the original purchase and the price of the replacement purchase of the item. And then, sorry, that letter was dated the 18th of August. So just 11 days later, on the 29th of August, we got this letter. Without prejudice, G4S Secure Solutions UK Limited. Thank you for your letter dated 18th of August, received 24th of August 23. Having regard for all that you say, we are instructed to put forward a settlement of £250 in respect of this matter. I spoke to Alfie and I said, listen mate, they've offered you 250 quid. I spoke to him and said we probably could potentially squeeze a little bit more out of them, but it would most likely take quite a while, and you could also risk losing the offer of the 250. So Alfie decided to accept that offer of £250. So we signed the agreement, and now the agreement is why I am making this video, not Alfie Audits. Put it on screen now. So you can see here, £250 offer made, G4S Secure Solutions, but it states here, look, I, the above named offeree, hereby accept the settlement offer in full and final satisfaction of all claims, whether made or not against the offerer that I may have, howsoever arising from my attendance at Folkestone Job Centre Plus on the 3rd of April 23. I acknowledge and accept that the settlement offer is made without any admissions of liability. Yeah, always. I further acknowledge and accept that acceptance of the settlement offer is confidential and no details pertaining to the settlement offer or any of the matters to which it relates may be shared, discussed or disclosed to any other person without express written consent of the offerer. Yeah, you want to keep it nice and quiet and hush hush hush, don't you?
So why are you broadcasting it?
For the purposes of executing this agreement, the settlement offer is to be made to me via bank transfer to the account as specified below by no later than 28 days from the date upon which the offerer receives this signed and completed form of acceptance. As you can see there, Alfie filled out his details and he signed it at the bottom. Now, I could have signed that letter on behalf of Alfie Audits. However, I chose not to because I am not being bound by those terms.
I disagree. Admittedly, G4S have been sloppy here. I assume because they didn't realise who Marti Blagborough was and that he had a YouTube channel. But I think Marti was obliged to keep the terms confidential. There's nothing to stop me reporting on it on my channel, by the way, as I'm just republishing information that is already public, and I owe no such duty to G4S. But both Alfie Audits and Marti Blagborough were under an obligation to keep it confidential, and that's now been broken by both of them. Alfie Audit's obligation was in contract. The document he signed has been breached by him because I assume Alfie authorised Marti to make this broadcast. I don't think even Marti Blagborough would upload this video without checking with him first. That means by uploading this video, Marti has potentially put Alfie Audits in breach of the obligation he signed, albeit indirectly. Next, Marti is under what is known as a duty of confidence. The English law of confidence has been developed through common law, which is part of English law that is derived from case law rather than statutes. The common law of confidentiality is a broad principle of law that a person who receives information from another party in confidence cannot take advantage of it. That person must not make use of it to the prejudice of a person who gave the information without obtaining that person's consent. The leading case in this area is the 1968 case of Coco and Iain Clark Engineers Limited. What happened in that case is that the judge formulated what has become the accepted framework for an action for breach of confidence, setting out 3 elements that are required to succeed in an action under the common law duty of confidence. First, the information itself must have the necessary quality of confidence. Whether or not the information has the requisite quality of confidence will depend on the relevant circumstances, but in most cases it's usually fairly straightforward to establish. For example, the information must not be something which is public property or which is already in the public domain. Second, the information must have been provided or made available in circumstances importing an obligation of confidence. That is to say, the defendant must have known or ought reasonably to have known that the information had been given in confidence. This involves an analysis of the relevant facts and circumstances, taking into account factors such as whether a. the information is classified as confidential between the parties, b. a duty of confidence should be implied due to the circumstances surrounding the disclosure, and c. a duty of confidence should be implied because of a relationship between the parties. The third element to consider is that there must be an unauthorised use of that information to the detriment of a party communicating it. To bring an action for breach of confidence, there must also be a use or disclosure of the information, either threatened or actual, without the consent of the disclosing party. Also, a party to whom confidential information is disclosed for a specific purpose would be in breach if they were to use it for another purpose without consent. I think the relationship between Marti Blagborough and G4S does meet the criteria for the imposition of a common law duty of confidence, which Marti has broken. You may think I'm making too much of this, as it was only a £250 settlement, but if you think about it, G4S and the DWP will be concerned by Marti's video because, without wishing to be unkind, Marti's viewers and fans include the type of people who might well think that they too can act up at a job centre somewhere and win themselves a few £100 compensation just for sending off a letter. That's their mindset. I'm not suggesting that G4S will bother taking Marti to court, you understand, that's very unlikely, but it wouldn't be hard for G4S to submit a privacy complaint to YouTube on the basis that, first, companies have a right to privacy just like natural persons under Article 8 of Schedule 1 of the Human Rights Act 1998, and any right of free expression under Article 10 due to the content's journalistic value cannot justify public disclosure of a settlement amount or the detailed terms of a settlement, or indeed a copy of the settlement itself. And second, Marti's content amounts to a breach of confidence.
Alfie is bound by those terms, and that's why Alfie signed that letter. So I am able to share this information with you today.
You're bound by that settlement as well. Apart from everything I've just mentioned about the law, Alfie must have returned the signed settlement to you, and you must have emailed it to G4S. We know this because you still have it. That means the settlement was not just returned to G4S under Alfie's ink signature, it was also returned to G4S under your electronic signature, with your full knowledge of what it contained, as you yourself confirm.
So, let me just make this clear. G4S Secure Solutions Limited, whatever the bloody name is, they assaulted Alfie. The police, they would not act on it, but as a civil matter, I could and I did successfully sue G4S Security.
You didn't sue them, you sent them a letter. Big difference.
And I got him a payout of 250 quid, which his camera was only worth 55, so 250 quid, it's a £195 profit. You can call that a profit, or you can call it the damages for the injuries, and the injuries, like I say, were very small bruises. You know, you'd probably struggle to get that awarded by a judge, to be quite honest with you.
£250 is what companies pay if they want to get rid of a nuisance claim that doesn't really have any merit, what lawyers call a vexatious claim. But that would involve some work to see off. It's a cost-benefit calculation that G4S have done here, and they've decided it's worth their while just to pay £250 nuisance money. You could argue that Marti has done well to extract £250 out of them, given there was no merit in the claim anyway. But £250 is what big companies pay for claims without merit that they don't want to go any further. That's because they have a lucrative contract with the DWP, and not upsetting the DWP with the PR damage of loads of these claims in court, plus the inconvenience of their own staff having to give evidence in court, is far more important than giving some random person £250. Avoiding all that is of far more value to G4S than paying out a few £100 for the odd claim. In other words, £250 is nothing to a big company like G4S. It's chump change. It's a good deal for them.
But yeah, so the security industry, they are not untouchable. You just have to know how to do it. And to be fair, I've just shown you how to do it.
You've just shown us how to send a letter. If we're generous to you, the letter was effective in extracting a nuisance payment for a vexatious claim.
If you want some help yourself taking action against a private security company, reach out to me. There's information in the description box. I will help you. I won't do it for free, but I won't do it I'm not going to charge you over the top. I'll do it for what's fair. The normal charge is 25%. That's what any legal firm will charge you. I won't charge you that. I won't even charge you close to that. So if you do need help and you want some legal help, get in touch and we'll sort something out. But it's a victory for the auditors. Security companies out there, you are not untouchable, and we will come for you, trust me.
I'm sure they're terrified after paying out £250 already. What next? Marti does need to be careful about offering these services, because Section 12.1 of the Legal Services Act 2007 does say that conducting litigation is a reserved legal activity, meaning it is a service that can only be provided by authorised persons, and Section 14.1 makes it an offence to do so. Authorised persons are regulated lawyers, law firm managers and people who work for them. Unless he's been hiding his light under a bushel, Marti Blagborough is not an authorised person. However, again, let me just stress, it's very important to be fair here, so far Marti has not carried out litigation services, as that expression is understood in the context of reserved legal activities. He's not conducting litigation simply by sending a letter before claim. Simply, just to emphasise, simply writing a letter before claim and giving advice and assistance is not conducting litigation. So Marti has not broken the law at this point, at least not on that particular issue. But if he is going to provide these services, he does need to be careful about any dealings he has with the court, and he needs to make sure he doesn't do something that could be regarded as conducting litigation, or he could be prosecuted as it's an offence. This will fall on deaf ears, of course, I know.
Yo, guys, thank you for watching. Another success. Hashtag Marti wins.
Hashtag Marti wins. Marti's certainly a winner. To sum up, Marti has infringed the privacy of Alfie Audits by revealing to us his real name, breached his own duty of confidence to G4S by revealing the terms of a confidential settlement. In the process, he has put Alfie Audits in indirect breach of that settlement too. extracted £250 from G4S in a vexatious claim. I should add he's also potentially put the security guards at Folkestone Job Centre in a position where they were disciplined, maybe even put out of a job. G4S is quite a ruthless company when it comes to dealing with their own staff, because they're at the political coalface, and there may be an expectation from the DWP that they deal with such incidents in that way. These are people on relatively low pay who have families to feed. Don't forget though that Marti is standing up for our rights. It's a good day's work for Marti.
Oh, and let me just add in clearly here, I didn't take a single penny off of Alfie, not a single penny. You can ask him yourself. No, he took the full lot. I didn't want nothing off him. It was my trial run of learning how to, proving to myself that I'm able to do this and I knew how to do it.
I think you've got some way to go.